want to talk to you about a recent case of Bennett v. State. It's a DUI conviction. And folks, a lot of these DUI convictions come based on some scientific evidence from an intoxilizer, from a toxicology report. We're going to talk about that. But first, Bennett was convicted of DUI. He blew into the machine and there was no alcohol in his system, zeros. And you know the cops, they get pissed off when they think there's alcohol in you and there isn't. So what do? They then move on to the urine. We'll now take another test. And this is not fair, but it happens all the time and it's half legal to do this. So Bennett takes a urine test and eventually they find that there is some drugs in his urine and they charge him with DUI. Now, when they go to trial, they've got the toxicology report from his urine that says there's drugs in your system. You need to convict this guy of DUI. So at the sheriff's office, when they create this toxicology report, there's a doctor that creates the toxicology report, does all the testing. And then there's a second doctor that kind of reviews and goes, yeah, okay, you did everything right, good. But at trial, guess what? The person that wrote the toxicology report to convict Bennett didn't show up at trial. The other doctor did. Dr. Shan showed up, the one that reviewed the report. And Bennett's attorney objected and said, wait a second. Dr. Shan didn't write this report. These aren't Dr. Shan's conclusions. This is Miller's conclusion, the person that wrote the report. This is hearsay. Everything Shan is saying is hearsay. Dr. Shan is just telling the jury what somebody else told him in the form of this report. Bennett lost and was convicted of DUI, and Bennett appeals the conviction. And on appeal, Bennett adds the real objection here is that Bennett was not afforded an opportunity to cross-examine the actual report writer, Miller. That's called a violation of your confrontation clause. That right is found in the Sixth Amendment to our Constitution. It says, look, we all get to confront our accusers. And the court on appeal said, Bennett, you're right. You are absolutely right. You had every right to confront the person that drafted that report, but your attorney didn't make the right objection. Your attorney objected on hearsay grounds rather than on Sixth Amendment confrontation clause, and also a case called Crawford. Had your attorney just said the magic words, your DUI would be kicked out. But your attorney didn't say the magic words. Your attorney said, oh, this is hearsay, Judge. Now, I think this ruling in Bennett's appeal is wrong. I think the court should have kicked out the DUI. I think that the hearsay objection at trial was acceptable. It wasn't the full scope of what went wrong. Absolutely. What really went wrong was that Bennett didn't have the right to confront the accuser, the creator of the toxicology report. That's what really went wrong. And I think the problem that I have with this whole opinion here is that Bennett did make a pretty good objection. Hearsay, folks, is in bed with confrontation clause, Sixth Amendment stuff. These two, even if they don't sleep in the same bed, they are in the same family, they are dating, whatever you want to call it, they are intertwined. So I think the hearsay objection was a good objection. It didn't go far enough for the appellate court, and so they weren't willing to overturn Bennett's conviction. But that's sad for Bennett, like this dude's DUI should have been thrown out, but because the wrong objection was made, or it was a good objection, it just wasn't good enough, it wasn't specific enough, he gets stuck with this DUI conviction. There you have it.